One fine day, Mukris was appointed as a managing director of a construction company, namely Mahakarya Sendirian Berhad. According to the company's articles, Mukris shall hold the office for a term of not less than 5 years, and no dismissal shall be exercised against him. In addition to that, the articles provided for a revision of his salary every 2 years. Recently, Mukris received a letter of termination from the company despite the fact that his tenure as director, as provided in the articles, had yet to expire. Mukris was so upset with the company's decision and wanted to challenge it. He also claimed that the company's failure to revise his salary in accordance with the term as provided in the articles amounted to a breach of contract.
Assalamualaikum warahmatullahi wabarakatuh. Today we are going to present Law 485, June 2016, question 2. My name is Muhammad Ilyas Amir Fazil. Next, we look at the issues. The issues are whether Mr. Mukris can file his claim on the ground of his termination before his dismissal term, and whether Mr. Mukris can file his claim on the ground of his company's failure to revise his salary. Right, next. The law. Under Section 2 Companies Act 2016, director is a person who is appointed to the position of a director where he involves in controlling the employees according to the rules that have been set out by the company. Managing or executive directors are involved in the day-to-day management of the company. As these individuals are involved in the management of the company, they may in practice have specific titles within the company. Alright. Under Section 33 Subsection 1 stated that the constitution of a company constitutes a contract between the company and its members and between a member and other members. The effect of this constitution is like a contract under seal and binds between them. It is also considered as a special contract. In the case of Rayfield against Hens, the company's articles of association provided that a member who wishes to transfer his shares must inform the directors, who were required to buy the shares equally between them at fair value. Rayfield wishes to transfer his shares, but the directors refused to purchase them. Then he took legal action against the directors to make them comply to the articles. He then also argued that as the directors of the company, they were also members and were bound to the articles to buy his shares. The court held that in the provisions in the articles were binding contract between Rayfield and the directors. Therefore, the directors were ordered to purchase Rayfield shares. Apart from that, there was no need for the company to be a party to the action, as the subject relationship was enforceable between the plaintiff as a member and the defendant not as directors but as the members.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Nur Syahmi bin Syari. So we move on to the next section. So under section 38 subsection 6 stated that a constitution law with the registrar under this section shall be binding on the company and its member to the same extent as if it was signed by each member and contain covenant on each member to observe all provision in the constitution. So in this section it's clearly stated that each one or each member on the company who already signed the constitution must follow all the provision that's stated in the constitution. So if anything happen, they have to follow all the provision stated in the constitution as they approve or agree on all the constitution that they have already signed. So on one decided cases, Salmon versus Queen and Extend Limited, based on this company article, that certain contract property matter could not be entered without the approval by both Salmon and Extend. However, in these cases, the board of directors proposed to acquire certain premises and to let the other premises, and by doing this, the Salmon refused the proposal. So, in order to overcome these matters, the board of directors has decided to decided to call for EGM, Emergency General Meeting, to approve the transaction without the approval of Salmon, and only pass the resolution that allow the decision to need only the extent approval. So the Salmon sued for injunction to restrain the company and the director from acting the resolution. So in the end of these cases, the court held that the resolution was inconsistent with the article, and the court granted the injunction because of in the article of company, it clearly stated that they have to need approved by Salmon, both by Salmon and extent. However, if it is only have approved by one only, in this case extent, so the proposal will be object. Next, under section 206, subsection 1, subsection 8, stated that the director may be removed before the expiration of the director period of office as subject to the constitution in the case of private company by ordinary resolution. Under the section 297, subsection 2, subsection 8, stated that a resolution under section 206 to remove a director before the expiration on his term of office. So, by this section, we can understand that if in the constitution stated that a director can be removed before his period of director's period of office as subject to the constitution. So, if anything happens, the director can be removed without any notice because it is already stated in the constitution. So in one decided cases, Sodiapan versus others versus Lim Yok Fan, the trial judge held that plaintiff were not properly appointed as a director, and as the 28 days notice required before the old director could be removed under section 128 had not been given. The High Court held that section 128 Company Act 1965 was not mandatory. The power to remove the director under that section coexists with any power contained in the AOA. Therefore, the 28 days notice is not necessary. The remove could be effected in accordance with the AOA. However, the proper notice required under AOA had not been given either. So, remove the director, and consequently the plaintiff was not properly appointed as director of the company. So, in this case, it means that the plaintiff were not properly assigned or appointed as the director. And under section 128, the 28 days notice also were not necessary because under the section above, it's already stated that if in the constitution has already stated that the director can be removed before the expiration date. So the plaintiff can be removed before the expiration date as stated in the constitution, and also the plaintiff can be removed because he is not properly appointed as the director. So the next one, under section 230 subsection 2, stated that in the case of private company, the board may, subject to the constitution, approve the fees of the director and any benefit payable to the director. Alright, thank you.
Assalamualaikum. My name is Muhammad Shazman bin Muhammad Shatta, and I will discuss the application of this case. For the first issue, Mr. Mukris can file a claim against the company on the grounds of termination before dismissal date because under section 33 subsection 1 and section 38 subsection 6 of the Companies Act 2016. The Constitution states that the dismissal date shall be not less than 5 years, and there shall be no dismissal before the expiration date. Thus, in this situation, Mr. Mukris, who received the letter of termination, despite the fact that his tenure as director, as provided in the articles, had yet to expire. The company needs to follow the Constitution, as the Constitution of the company is above the law under Companies Act. The Constitution is also an agreement that binds the company with the members and between members. By breaching this agreement is like breaching the law itself. For the second issue, under private company, Mr. Mukris can file a claim against the company on the ground of failure to revise his salary because the Constitution of the company states that the company need to revise his salary for every 2 years. Thus, the existence of the Constitution shows that it is approved by the members of the company to pay remuneration to Mr. Mukris. Failing to do so means a breach of contract of Constitution. As a conclusion, Mr. Mukris can file his claim against the company on the ground of breach of contract by the company under termination and remuneration. That is all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Zulizan bin Sazali Donald. Today we are going to discuss about June 2015 question 2B. So this question is asked about condition laid down by law as to valid alteration of the articles of association of a company. So what is the article of association? Article of association is also known as the constitution of the company. So what is the definition of the constitution? Constitution, we can say that the constitution under section 33 subsection 1 to Companies Act 2016 says that constitution of company is a contract between the company and its member and between a member and the other members. So the effect of the constitution is like a contract under seal and binds between them. So the other definition of constitution is we can see under section 38 subsection 6 Companies Act 2016. It states that the constitution lodged with the registrar CCM Companies Commission Malaysia under this section shall be binding on the company and its member to the same extent as if it was signed by each member and contain covenants on each member to observe all provision in the constitution. So the alteration itself, so we know the definition of the constitution. So we also can alter the constitution. There's two ways of alteration of the constitution of the company. First is by the alteration by the company, and second is alteration by the court. So alteration by the company is under section 36 Companies Act 2016 by passing a special resolution, except where the alteration prohibited under the constitution itself, or if there were interference by the court, as in section 37 subsection 1 Companies Act 2016. In Treatise American Delicacy Against Health, it was decided that any agreement between the company and its member and between the members to restrict the alteration of the company articles of association is of no effect. So the alteration must be bona fide for the benefits of the company as a whole and must affect every member and must not be discriminatory as decided in case Grihe against a dream Ardin Cinemas. So that's it from me. Thank you.
Hi, my name is Muhammad Imadanya bin Azman. First of all, I would like to thank Mr. Zul for explaining the first type of companies alteration of constitution by a company. Now, I shall explain the second type of alteration of constitution by the court order. Okay, in a certain situation that it is not practical to alter the constitution by using the procedure that has been set up in the Companies Act or the constitution itself. Thus, section 37 says director or member may apply to alter by using the court order. Then the court may grant the order if it thinks that it is not practical to amend the constitution by using the procedure set out in the Company Act or the constitution itself. And also the court may grant the order under a certain term and condition. After following the procedures to amend the constitution, the amendment must be lodged with the registrar of companies as stated in the section 36 subsection 3 Companies Act 2016, where the company must lodge a copy of the altered constitution within 30 days of passing of special resolution. The alteration date is the same date of the special resolution were passed or at the date where it is stated in the special resolution under section 36 subsection 2 Companies Act 2016. Whereas for the alteration by the court, the company must submit the altered constitution together with the court order within 30 days of the court order. If the company fails to do so, thus the company or the member that involved in the alteration shall be in offence. What is the effect of the alteration? First, on member, the alteration will take effect on the day of the resolution is passed, or at a later date, mentioned in the resolution itself. While the alteration by the court will decide the date of the alteration. Thus, when it is effective, all the members shall bind in the company's new constitution. Okay, that's it from me. Thank you.